Oil states and Greene's Energy are energy companies working with the new technology in fracking, in oil extraction. Oil states, or more specifically one of its subsidiaries, had a patent on some new fracking technology. It sued Greene's Energy in court for infringement of that patent. Greene's Energy filed a petition to invalidate Oil States' patent at the Patent Trial and Appeal Board, whose purpose is to cancel or invalidate issued patents. The Oil States versus Greene's Energy case raised a fundamental question about the status of patents as property rights, as protected under the Constitution through either the Seventh Amendment's requirement that everyone receive a jury trial for the protection of their rights to life, liberty, and property, and through the separation of powers doctrine. The distinction between public rights and private rights was fundamental to the Oil States versus Greene Energy's case. And one of the ways that the courts have typically managed this distinction is to try to identify the provenance of the legal right at issue. Is it found in common law, or is it found in statutes or regulations? As a first cut, if a right is found in its origins in a regulation or in a statute, then it's a public grant. If it's found in common law, the classic source of our rights of life, liberty, and property, then it's a private right. But in a certain sense, this distinction between statutes versus common law isn't really precise. In Oil States, the court split 7-2. Justice Thomas wrote the majority opinion for Oil States, and in fact, it was joined by other justices across the spectrum, Justice Ginsburg, Justice Alito, showing that patent cases are not typically cases where you have judicial conservatives and judicial liberals splitting along those lines. The Supreme Court, for the first time, fully embraced the view of patents as public franchises, as regulatory entitlement grants. Justice Thomas held that this is proper, given that patents are in fact public rights on par with toll roads, toll bridges, and even public utilities, regulatory entitlements that are accorded by the government by privilege. Therefore, they do not receive the full protections of the Constitution. And the PTAB, as it exists, is simply the converse of the grant of a patent. The Patent Office can choose the conditions under which it grants the patent per the statutes that Congress has enacted, and the Patent Office can therefore revoke the patent per the conditions that Congress has enacted in the statutes. The separation of powers was a key element of the Oil States case and ended up being fundamental to the entire decision, as opposed to the Seventh Amendment jury right that seemed to be ostensibly the issue presented to the court. Justice Thomas explained that the Patent Trial and Appeal Board, the PTAB, does not violate the separation of powers and the requirement that our private rights are adjudicated by Article III courts, simply because patents are public franchise grants, and therefore belong solely within the domain of the administrative state and the discretion of the executive branch. The Oil States decision fundamentally does affect how we think of patents today. It calls into question the status of property rights that are secured or defined by statutes, which are most property rights today, and places them, under its logic, firmly within the domain of the administrative state, continuing to grow this fourth branch of the government in the executive branch, in power and in unconstrained and unlimited abilities to dictate to us how we live our lives and how we use our property today.